You're sitting in your car. The officer's at your window. And then his hand moves toward your door handle. Every single day, drivers across America make one catastrophic mistake in this exact moment. A mistake that turns a simple traffic stop into a full vehicle search, an interrogation, and sometimes an arrest. The trigger? The officer says something that sounds casual. Why don't you step out for a second? Or he just reaches for your door. I've analyzed over 300 cases where this moment decided everything. I've studied Supreme Court rulings, reviewed hundreds of body cam videos, and researched police training manuals. In the next 19 minutes, I'll show you 5 critical mistakes drivers make when police attempt to enter their car, and the exact words that protect your constitutional rights without escalating the situation. Because what you do in the next 10 seconds can be the difference between driving home and sitting in handcuffs. Mistake number 1. Opening your door when they have no legal right. The biggest mistake drivers make is voluntarily opening their door the moment an officer asks them to step out. Picture this. You're pulled over for a broken taillight. The officer walks up and says, "Go ahead and step out for me." Most people immediately unlock their door, swing it open, and step out. They think they're being cooperative. The moment you open that door, you've just given the officer lawful access to your vehicle's interior. Here's the legal reality. Your car is protected under the Fourth Amendment. Courts have ruled that the interior of your vehicle has a reasonable expectation of privacy. Officers cannot simply open your door and look inside without your consent, probable cause, or a valid search warrant. When you voluntarily open your door, you're giving consent. Once that door is open, everything in plain view becomes fair game. Body cams record this moment. And on camera, your action of opening the door looks voluntary. Even if you felt pressured, the video shows you opening the door yourself. Here's what officers are trained to do. They use language that sounds like a request, but feels like an order. Go ahead and step out. Why don't you come talk to me at the back? None of these are technically orders. They're suggestions designed to make you comply without the officer needing legal justification. The correct move requires you to control the moment. Keep your door locked. Keep your window rolled down only 2 to 4 inches, just enough to hand documents through. And before you do anything else, clarify the legal status. Here are the exact words. Officer, are you asking me or ordering me to step out of the vehicle? Say it calmly. Say it respectfully. But say it clearly. This one sentence forces the officer to reveal whether you have a choice. If he says he's asking, you have the right to decline. You respond, "I prefer to remain in my vehicle. I do not consent to opening my door." Notice those words. I do not consent. That phrase creates a clear record that whatever happens next is not voluntary. If the officer says he's ordering you to step out, then you must comply, but only after taking one more critical step. Why does this work? It puts the legal burden on the officer to justify his authority. If he has a lawful reason to order you out, he'll state it. If he doesn't, he either has to back down or escalate without legal justification. Let me show you what happens if you skip this step. The officer wasn't planning to search your car initially, but your door opens, and he sees a gym bag on your back seat. Now he asks, "What's in the bag?" You say, "Just gym clothes." He says, "Mind if I take a look?" The officer opens the bag, finds a bottle of prescription medication. Now you're explaining why you separated pills from their container. The officer doesn't like your answer. He calls for backup. Suddenly you're being questioned about drug possession because you opened a door you never had to open. The bottom line: never voluntarily open your door unless you've confirmed the officer has a lawful right to order you out. Stay locked, stay in control, and make the officer state his legal justification. That protects your Fourth Amendment right against unreasonable searches. But even with your door locked, you can still lose control through what you say. That's where Pennsylvania versus Mims comes in, the Supreme Court case that gives officers specific authority. Mistake number 2 is not knowing the limits of that authority. Mistake number 2, not clarifying whether it's a request or an order. The second mistake drivers make is failing to distinguish between a request and a lawful order before they comply. The officer is at your window, your door is still locked, and the officer says, "I need you to step out of the vehicle." Most people immediately think they have no choice, so they unlock the door and get out. But the officer never actually ordered them out. He used language that sounds like an order, but legally, it might have been a request. In Pennsylvania versus Mims, the Supreme Court ruled that officers can order a driver out of the vehicle during a traffic stop for officer safety reasons. But this authority is not unlimited. The officer must have a legitimate safety concern. When an officer says, "I need you to step out," that's ambiguous. And if you treat a request like an order, you've just given consent when you didn't have to. The correct move is asking, "Officer, are you asking me or ordering me to step out of the vehicle?" Scenario 1. It's a request. Officer says, "Why don't you step out?" You ask, "Officer, are you asking me or ordering me?" Officer responds, "I'm asking." You say, "I prefer to remain in my vehicle. I do not consent to opening my door." The officer can either accept your refusal or escalate to giving you an actual order. If he escalates, you've created a clear record that shows you did not consent voluntarily. Scenario 2. It's an order. Officer says, "Step out of the vehicle." You ask, "Officer, are you asking me or ordering me?" Officer responds, "I'm ordering you." You say, "For the record, what is the lawful reason for ordering me out?" This forces the officer to articulate his justification. If he has a valid safety concern, he'll state it. Whatever the reason, it's now on record. If the officer refuses to give a reason, you've documented that the order may not be lawful, but you still comply. You do not refuse a direct order. Here's how you comply. I am complying under protest, and my hands will stay visible. Say it clearly before you open the door. This shows you're following the order, so you can't be charged with resisting. It creates a record that your compliance is not voluntary, and it keeps the focus on your hands. If you skip this step on body cam footage, it looks like you willingly complied. Later, the officer writes that you voluntarily exited the vehicle. That makes it much harder to challenge anything that happens next. But if you ask for clarification first and state you're complying under protest, the body cam tells a different story. The footage shows you asked if it was an order. The officer confirmed it was. You asked for the legal reason, and you stated you're complying under protest. The bottom line: always clarify whether you're being asked or ordered. If it's a request, you can decline. If it's an order, comply, but announce you're doing so under protest. Pennsylvania versus Mims only addresses physical compliance. It doesn't address your other constitutional rights once you're outside. After complying with the order to exit, most people assume the officer now has broader authority. He doesn't. Mistake number 3 is failing to announce your non-consent even after you've been ordered out. Mistake number 3, failing to announce non-consent after exiting. The third mistake is assuming that once they've been ordered out of their vehicle, they've lost all rights. The officer ordered you out. You complied under protest. Now you're standing outside your car. And the officer says, "I'm going to take a quick look inside." Or he just opens your door. Most people think the battle is over. They already got out. The officer must have the right to search now. Wrong. Here's the legal reality. Getting out of your vehicle does not give the officer automatic authority to search it. Those are two separate legal standards. Pennsylvania versus Mims gives officers the right to order you out for safety. But searching your vehicle requires your consent, probable cause, or a warrant. When you fail to announce your non-consent after exiting, officers often interpret your silence as implied permission. The correct move is to make your non-consent crystal clear. Here are the exact words. Officer, I do not consent to any searches of my vehicle or my person. Say it calmly, say it clearly, say it loud enough for body cams to pick it up. Officer says, step out of the vehicle. You respond, for the record, what is the lawful reason? Officer says, officer safety. You say, I am complying under protest. My hands will stay visible. You step out. Officer positions himself near your vehicle. You immediately state, Officer, I do not consent to any searches of my vehicle or my person. Officer says, I'm just going to take a quick look. You repeat, I do not consent to any searches. Officer says, you got something to hide? You respond, I do not consent to any searches. I am invoking my right to remain silent. You're repeating your non-consent every time the officer tries to minimize or pressure you. You're not arguing. You're simply restating the legal boundary. Here's what officers are trained to do after they get you out. They try to use conversation to build probable cause. They ask where you're coming from, where you're going. They ask if you have anything illegal. They ask if you mind if they look. Every question is designed to get you talking. If you fail to announce your non-consent, the officer orders you out. You comply silently. You stand there while he walks to your car. He opens your door. He looks in your center console. He sees a knife. And now he's asking why you have it. All of this happened because you never said, I do not consent. The bottom line. The moment you exit, announce clearly and repeatedly that you do not consent to any searches. State it proactively, and state it every time the officer approaches your car. You've protected yourself through physical compliance and verbal non-consent, but there's another protection that applies before the officer orders you out. The plain view doctrine. Mistake number 4 is giving officers visual access to your interior that you never had to give. Mistake number 4. Not controlling the plain view doctrine. The fourth mistake is failing to control what officers can see inside their vehicle. You've been pulled over. The officer walks up. Your window is rolled all the way down. Your interior lights are on. Your glove box is open. There's a gym bag on your passenger seat, half unzipped. The officer hasn't asked a question yet, but he's already gathered evidence because you gave him plain view access. Here's the legal reality. Officers can seize evidence in plain view if they're lawfully present, the item is immediately recognizable as evidence, and they have lawful access to it. The plain view doctrine is one of the most powerful tools officers use. If they can see something suspicious through your window, that gives them probable cause. And once they have probable cause, your non-consent doesn't matter. The correct move is to control your windows, your lights, and your interior visibility from the moment you're pulled over. As soon as you see those lights, before the officer exits his vehicle, you execute the first 30 seconds protocol. Step 1. Pull over safely using your turn signal. Step 2. Turn off your engine. Step 3. Lock all your doors. Step 4. If it's dark, turn on your dome light. This shows you're not hiding, which reduces officer safety concerns. Step 5. Roll your driver's side window down 2 to 4 inches only, just enough to slide documents through, not enough for the officer to have a clear view of your entire interior. Step 6. Place your hands on the steering wheel where they're visible. Step 7. Announce as the officer approaches. Officer, I'm locking the vehicle and will hand you documents through the window. This addresses every officer's safety concern while maintaining your Fourth Amendment protections. Most people get pulled over, leave the engine running, start digging through their glove box before the officer approaches. Their window is rolled all the way down. By the time the officer walks up, he's seen everything in plain view. When you roll your window all the way down, you give the officer maximum visual access. He can see your entire front seat, your center console, your floor, often your back seat. Every item in plain view becomes something he can ask about. But when you keep your window cracked, you control the viewing angle. The officer can see you clearly. He can see your hands, but he cannot see your entire interior. And what he can't see, he can't use as probable cause. The bottom line: before the officer approaches, roll your window down only 2 to 4 inches. Keep your interior visibility limited. Control what's in plain view. Because what an officer can't see, he can't use against you. You just learned how to control visual evidence, but even with perfect window control, officers still have one more powerful tool: your own words. Mistake number 5 is the most common and most damaging. Here's what happens after you're out and why answering questions destroys everything you've protected. Mistake number 5: answering questions after exiting the vehicle. The 5th and most dangerous mistake is answering questions after they've been ordered out. You've done everything right. You locked your doors. You cracked your window. You asked if it was a request or order. You announced non-consent. You complied under protest. You controlled the plain view. Now you're standing outside your car, and the officer says, "So, where are you coming from tonight?" It sounds like casual conversation. Most people think the hard part is over. They answer, "Just coming from a friend's house." The officer says, "What were you doing there?" You say, "Just hanging out, having a few drinks." You just gave the officer probable cause to investigate you for DUI. After you'd successfully protected every other right, here's the legal reality. Nothing you say to an officer outside your vehicle is private conversation. It's interrogation. It's being recorded on body cam. Every answer can be used as evidence. The correct move is simple. Cooperation does not mean conversation. You can be polite, respectful, and compliant without answering a single question. Here are the exact words. "Officer, I am invoking my right to remain silent. I will not answer any questions without my attorney present." Say it clearly, say it calmly, and then stay silent. Don't explain, don't justify, don't apologize. Just stop talking. Officer asks, "Where are you coming from?" You respond, "I am invoking my right to remain silent." Officer says, "It's just a simple question." You repeat, "I will not answer questions without my attorney present." Officer says, "You got something to hide?" You say nothing. This silence feels uncomfortable. But here's what you need to understand. Salinas versus Texas established that you must explicitly invoke your Fifth Amendment right. Simply remaining silent is not enough. Your silence can be used against you if you don't explicitly invoke the right. That's why you must say the words, "I am invoking my right to remain silent." Here's what officers are trained to do. They start with easy questions. Where are you coming from? Where are you going? They're trying to get you comfortable talking. Once you're talking, they escalate to harder questions. Have you been drinking tonight? When was the last time you smoked marijuana? Do you have any weapons in the car? If you answer any questions, you've opened the door. Now the officer can ask follow-ups. With each answer, you're giving him more ammunition. The bottom line: the moment you exit your vehicle, Invoke your right to remain silent and request an attorney. Do not answer questions. Do not engage in conversation. Your job is not to convince the officer you're innocent. Your job is to protect yourself legally. Here's the core principle. When police attempt to enter your car, your power lies in clarity, documentation, and silence. Never voluntarily open your door. Always clarify whether you're being asked or ordered. Always announce non-consent to searches. Always control your window and interior visibility. And always invoke your right to remain silent. These are the 4 phrases that protect you. 1. Officer, are you asking me or ordering me to step out? 2. I am invoking my right to remain silent. 3. I do not consent to any searches. 4. I want to speak with my attorney. Memorize these phrases. Practice them until they're automatic. Because in the moment, when your adrenaline is high and an officer is standing at your window, you won't think clearly. You'll default to what you've practiced. This is educational content only. For specific legal advice, consult a licensed attorney in your state. If this video helped you, hit the like button. Subscribe for more legal education content. Turn on notifications. And share this with someone who needs to know these protections. You just learned how to protect yourself when police attempt to enter your vehicle. But there are other constitutional protections that apply in different stages of police encounters. Rights that have different invocation requirements and timing rules. I analyze those other legal frameworks in the next video so you understand when each protection applies. That analysis is on screen now. Your car is your castle. The Constitution protects it. Now you know how to enforce that protection.